Well, good afternoon, everyone, and welcome, and thank you for joining us for today. This is a presentation by Sherman Sterling about international arbitration and Industry 4.0. The presentation today is just get the slides back up. Great. So my name is Jennifer YOUNAN. I'm a partner in the International Arbitration Group of Shearman based in Paris. And what we wanted to present today, we're sort of going to build blocks. We're going to start by telling you a little bit about our law firm, Sherman Sterling. We're going to talk to you a little bit about what international arbitration is and how it differs to other forms of dispute resolution, in particular litigation. And also talk you through some of the types of international arbitration disputes that you would typically see. We then wanted to focus on international arbitration in the region, and finally, obviously coming back to the topic of the forum, look at international arbitration and Industry 4.0, how international arbitration can be of assistance in the types of disputes you have, for example, in the context of smart contracts, but also how things like artificial intelligence are having an impact on the way we work in international arbitration. So we're going to cross sort of a broad spectrum of topics, and of course we'll invite any questions that you may have probably at the end of the presentation. So beginning with Sherman Sterling, it was founded in 1873 in New York, so originally an American law firm, and it expanded internationally in the post-World War II era. It was one of the first law firms to have a presence in key international markets. The firm's first international office opened in Paris in 1963. And as of today, we have 850 lawyers around the world, speaking 64 languages, and nearly half our lawyers practice outside of the US. So we have 24 offices around the world covering all major business centres. Now, we're a full-service law firm, and essentially by that we mean we have practice groups that cover almost, as you can see, every area, and this is sort of an example: mergers and acquisitions, finance, international arbitration, tax. Today we're focusing on international arbitration, but we obviously offer a whole spectrum, and we do transactional work, advisory work, non-contentious and contentious work. And as well as organising ourselves in practice groups, we also have industry focus, which you see a lot of international law firms doing now, which essentially means we also organise ourselves against key industries where our clients work, and we pool our expertise across the practice groups in an attempt essentially to give clients more of a sort of a holistic solution to their problems. And so we do this globally across our offices and across our practice groups for particular industries. Now, as I mentioned at the outset, we were one of the oldest law firms, and we have a long history of working on a number of quite groundbreaking and what were sort of precedent-setting matters. We've put a few representative matters here on the screen. And if I take you just through some of them, in post-war Germany, Sherman helped Germany settle its external tax debt. It assisted companies such as Siemens at the time restructure their debts and re-emerge as credible exporters. We represented Citibank in intense negotiations that ensued in the Iran hostage crisis after the US government, in that case, froze all Iranian assets in the US banks. We helped restructure debts of many Latin American nations during the Latin American debt crisis, and thereby assisting in averting what was a pending global financial crisis at the time. We advised Germany on the privatizations of the former East Germany state-owned chemical, mining, and energy sectors. We assisted Kuwait in seeking unprecedented reparations for environmental damage, which was inflicted by Iraq during the Iraq-Kuwait War. And we also advised Mexico in the negotiation of NAFTA, of course the North American Free Trade Agreement, which has recently been replaced, as you probably know, in recent negotiations between the states. That's a little bit about Sherman. What we wanted to focus on is the practice group that we come from, which is international arbitration. The Sherman team is widely regarded as one of the very best in the market. It's led by Professor Emmanuel Gaillard, and it includes more than 100 lawyers who are dedicated solely to international arbitration. We have over 40 years of experience in the field of international arbitration, and we've resolved more than 1,000 disputes during that period. And just taking a little bit of a look at what our team actually looks like. So 125 dedicated professionals, broken down, as you can see, amongst partners, counsels, associates, trainees, legal assistants and support staff. So these are people working exclusively within international arbitration. Just looking at the partners and counsel, we're distributed across our offices across the globe with a strong presence in particular in Europe, in our Paris office. And as you can probably imagine, given the nature of international arbitration, we have lawyers who come from many different backgrounds. And so we speak amongst ourselves and work in 29 languages. And we've highlighted here, obviously, the languages which are pertinent to this region. And so depending on what matter we're working on, you know, we're often working in either English, French, Arabic, Russian, Ukrainian, Serbian, depending on the matter. And our international arbitration group and the associates in that reflect the kind of matters that we're working on. This is just out of the over 100 people in the team. We've sort of selected here those who are active in the region, which obviously includes the three of us. But as you can see, quite a few associates who either come from the region or have a particular interest in the region. And this is just a little bit of how clients see us. As some of you probably know, Chambers and Partners ranks the top law firms and lawyers and ranks us in band 1, global-wide, Europe-wide, Africa-wide, and in France. So that's a little bit about who we are as Sherman and Sterling and as the International Arbitration Group. But what we wanted to talk to you about is a little bit about international arbitration itself. So how it works, what are its key characteristics, and how it compares to litigation. Now, in an increasingly globalized world where you have lots of disputes happening across borders, parties from different countries are often looking for a neutral forum in which to settle their disputes. So, for example, if we have a dispute that arises between a Greek party and a Bosnian party, they're often reluctant to submit their dispute to either national court system, and so they will often choose what they deem or consider to be a neutral forum, and that's where they often opt for arbitration. And so 3 characteristics that we often use to define arbitration is that it is consensual, and by that we mean both parties agree to submit their dispute to arbitration. They often do that in the form of an arbitration agreement, which is typically put in their contracts before any dispute arises. It's private, and by that we mean this is all taking place outside of the court system. So we're not in any national court system. It's quite unique. And it's final in that it's a method of dispute resolution that provides a final and binding outcome with very limited grounds of challenge. And obviously the benefit of that is the parties avoid the cost of very protracted appeals process. Now, just looking at some of the sort of curious features that distinguish it from other forms of dispute resolution, one of the most obvious ones is how you constitute the arbitral tribunal. Now, arbitrations are typically conducted by either 1 or 3 arbitrators, and we refer to that as the tribunal. And that's essentially the equivalent of a judge or a panel of judges that you would have in a court action, except in this case the arbitrators are actually selected by the parties to the arbitration in accordance with their arbitration agreement. It's one of the first steps that you would take in the arbitration. It's also one of the most important steps in the arbitration, because obviously whoever you have deciding the dispute is going to be a crucial decision as to how that arbitration unfolds. So we always advise people to do that with their legal counsel on board, preferably. How you go about doing that, if you have 3 arbitrators, and that's what's provided for in your arbitration agreement, essentially what happens is one party chooses their arbitrator, so that's referred to as the co-arbitrator. The opposing party will choose their arbitrator, And together those two arbitrators will choose the chairperson. Now, where the parties are of different nationalities, either the sole arbitrator, or in this case the chair, normally will not have the same nationality as either of the parties in an effort to ensure neutrality. Looking at what an arbitration looks like, so again, unlike a court proceeding, it's incredibly flexible. One of the defining characteristics I mentioned is that it's consensual, it's voluntary. So essentially the parties decide what they want their arbitration to look like. This is sort of the typical, in broad terms, phase. So you have a preliminary phase where you constitute your arbitral tribunal. You have a pleading phase which will typically involve 2 rounds of submissions and possibly document production. If the parties choose to put it in, the parties can also choose to exclude document production. Then a hearing, and then the tribunal will render an award. Now, typically, though this can vary, an arbitration you would expect to take 1 to 1.5 years. That, however, could be quite different, and this will be touched upon perhaps later when you look at investment arbitrations, where you're looking at a dispute between an investor and a state, and they're typically much longer and more protracted. So in addition to choosing your arbitral tribunal, you also get to choose the arbitral rules that are going to govern the conduct of your arbitration. And essentially your choice is between either going for an ad hoc arbitration or an institutional arbitration. An ad hoc is basically conducted under rules which are adopted for the specific purpose of that arbitration without the involvement of any arbitral institution. So the parties could essentially write up their own rules if they wanted, or they could adopt what it tends to be the standard form rule, which is the UNCITRAL arbitration rules. Alternatively, you could opt for an institutional arbitration, which involves incorporating the rules of an existing institution, which will then administer the arbitration for you. Now, the best known ones are some of the ones indicated here: the SCC, which is the Stockholm Chamber of Commerce; VIAC, so the Vienna International Arbitration Centre; the LCIA, the London Court of International Arbitration; and the ICC, which is the International Chamber of Commerce, which is based in Paris. This slide talks about the arbitral seat. Essentially, the arbitral, amongst the things you choose, so you've chosen your set of rules that you apply, you've chosen how to constitute your arbitral tribunal, you also get to choose the place of the arbitration, or what we would typically call the seat of the arbitration. And what we've shown you here are what are the most popular seats that are chosen by the parties, but of course, again, you're at liberty to choose whatever seat you want for your arbitration. The only thing to bear in mind is that it can have a number of important ramifications for your arbitration. So it is a decision you want to take judiciously, and again, with the advice of counsel. It can affect the arbitration in a number of ways. It affects it by reference to the legislative framework which is going to apply. It affects it to the extent that the courts can get involved in certain instances, and it will have an impact on enforcement when it comes to enforce the awards. And we typically talk about certain countries being either arbitration friendly or less arbitration friendly, depending on how interventionist their courts are. But you'll find sometimes in an arbitration that you will have reference to courts if you need some kind of interim relief. So you might have resort to courts for discovery of documents, for example. As we'll come to see later, when it comes to the issue of enforcement, the seat of the arbitration is also a very important factor. Now, arbitration has grown exponentially in the past decade. It's an incredibly popular form of dispute resolution. And there are a number of reasons for that. There are a number of advantages that it offers over litigation that makes it attractive to businesses in cross-border or transnational disputes. And so what we've done here is to highlight what most people would identify as the key advantages of arbitration. The first, probably the most important, is enforceability. Now, the ease of enforcement of arbitral awards is viewed as a key advantage of arbitration. If you opt for litigation, Local court judgments are, of course, immediately enforceable within the specific jurisdiction in which they're rendered. But if you have to go and enforce it overseas, so if you have assets overseas that you're trying to seize and you need to enforce that judgment overseas, there's no mechanism to do that. And so you have to go before each individual court and try and get your award or judgment in that case recognised in the individual jurisdiction. It's completely different for arbitration. And that's because in the case of arbitration, we have the New York Convention on the Recognition and Enforcement of Arbitral Awards, which provides a unique enforcement regime for international arbitration awards. So this is essentially an international treaty, and it provides for reciprocal enforcement of arbitration awards, as you can see here, in 162 countries. So these are the number of contracting parties to the New York Convention. So if you come back to the seat of the arbitration, when you select a state that is a party to the New York Convention as the seat of your arbitration, you can see that that is going to greatly facilitate the enforcement because you get reciprocal enforcement in all these countries. Another virtue of arbitration is, of course, its neutrality. So the neutrality of the court system can vary greatly between one state and another. Arbitration, by contrast, provides a neutral forum. And that's attractive for commercial entities that may be wary of referring disputes to the home courts of the opposing party. Specialisation is another important factor. So domestic court judges typically are generalists. They see a number of disputes in a variety of sectors. The beauty of arbitration, of course, is you're selecting your arbitrators. So if you want them to have a particular expertise, you can choose arbitrators who have that skill set. And of course, they don't necessarily need to be lawyers. So if you have a construction dispute, you'll choose construction lawyers, an IT dispute. And as we'll see later on, if you're dealing with smart contracts, you can choose arbitrators who have the expertise and knowledge in that area. So again, that's a very large advantage over the court system. And the fourth advantage is privacy and confidentiality. So in litigation, decisions issued by national courts are usually public. In arbitration, parties can agree, again, everything's consensual, to confidentiality, and in some jurisdictions it is assumed. Again, later when we come to discuss a little bit investment arbitration, so looking at disputes between investors and states, we'll see that confidentiality, there's much more of a push towards transparency in those cases because you're dealing with states and therefore public interests. So that's a slightly different case to commercial arbitrations. And the other is flexibility. When you go before a commercial court, you're subject to the procedural rules of the court. Arbitration, as you can just see from this sort of small introduction, allows the parties to tailor the proceedings to what they want. You choose your arbitral tribunal, you choose the set of rules that you want to apply, you choose what the procedure will look like, you choose the seat of the arbitration, and that flexibility is obviously very attractive for parties. I guess just summarising that, there was a recent survey conducted of respondents who use the international arbitration system, asking them the 3 most valuable characteristics of international arbitration. And you can see here what they valued in the order of importance. Enforceability of awards, 64% highlighted that as the most valuable characteristic, followed by avoiding specific legal systems or national courts. Flexibility was the next advantage. The ability of parties to select arbitrators. Confidentiality and privacy was next. Then neutrality, finality, speed. Unfortunately, cost comes low. We do try to think of arbitration as being cost effective, and it certainly can be if the parties choose the right kind of mechanisms. But that's certainly something that I think parties need to work on in trying to bring costs down in arbitration. But you can see that the main virtues always are the ones that we discussed at the beginning, and it's the ability to tailor it to your dispute that makes it so attractive to parties. So that's a little bit about international arbitration. coming back to what we do at Shearman in the International Arbitration Group, we really assist at all stages of an international arbitration. So in the pre-arbitration phase, so if it's drafting an arbitration agreement, if it's providing initial advice on a dispute, in the actual arbitration phase in terms of obviously developing a strategy with the client, drafting the pleadings and doing the oral advocacy, and importantly, and not to be forgotten, once you receive an award, in actually enforcing that award in the various jurisdictions in which you believe the assets are located. So we're across the spectrum in terms of the services that we provide. The next thing we wanted to discuss was the type of international arbitration disputes, and for that I'm going to pass on to my colleague, Ilija MITREV PENUSHLISKI, who's going to do it for
Dobar dan, moje ime je Ilija MITREV PENUSHLISKI, ja sam iz Makedonije. Čast mi je da budem danas ovdje na ovom odličnom događaju, jer naša je prezentacija interaktivna i naš kopanelista ne priča srpski, onda ću ja da pričam na engleskom isto, ali vi možete da me pitate na srpskom, naravno. So the general, I'll have to skip a few of the slides given the time constraints, but the general theme of this third topic is the types of international arbitration disputes that arise. And I know that we are here to talk about cooperation and growth and progress and development, etc. But with the rise of global commerce and global transactions, friction is inevitable and disputes will arise. As someone has once said, contact generates conflict. So international arbitration can resolve essentially all types of disputes insofar as there is a contract. And there are some cases where international arbitration can also serve as a means of dispute resolution even if there is no contract. The main categories of disputes that are being resolved by arbitration are the ones that I've set out on the screen. I'll walk you through those in some expeditious fashion, I think. But you should know that in addition to this category, we could add another one, which is online arbitration. We're not going to discuss about that, but we will discuss a little bit about smart contracts and arbitration and AI and arbitration later on. The 6 categories, quickly. To go through the first, construction. Construction is your archetypical arbitration dispute, given that very little can be defined at the outset in huge and complex construction projects. There are items that appear in the middle of a project. Someone delays the construction, someone forgets to provide or doesn't provide a timely approval, and who is to be blamed? Is it the contractor? Is it the supplier? What do we do when a hospital or a road or a power plant is not built in time? Arbitration is very commonly used to resolve those disputes, and we have acted for suppliers and contractors in over 200 cases of this sort. Recently represented Algerian Sonatrach against the Italian giant Saipem in a 2.5 billion euro case. Energy is the other category of disputes that you very often see in arbitration. Practically any type of energy carrier you would see in an arbitration, whether it is a question of exploration and production of oil, gas pricing, long-term power purchase agreements, and more recently renewables, wind, solar, and even something that's becoming quite trendy is the arbitration of carbon credits disputes. So when you buy and sell carbon credits. The number of cases that we've done in the energy field is very significant. Currently I'm involved in a large dispute representing the Republic of Lithuania and the city of Vilnius against a multinational utilities company in the domain of district heating and power generation. And we frequently do also gas pricing disputes. How do you reset the gas price when there is no traded, and there is no gas index? And especially, how do you do that when the benchmarks in the market become misaligned with the contractual price? That is a domain of its own, gas pricing. M&A disputes are likewise very common in the arbitration domain, whether it be post-acquisition disputes, joint venture disputes, shareholder disputes, or other corporate combinations that may result in friction between one or more parties, with two or more parties, excuse me. In another general umbrella category are the general commercial disputes, and there effectively you can have an arbitration related to any type of contract, sales, services, distribution, lease agreements, concessions, and so on. And this is a very prevalent category of disputes. I would add that intellectual property rights disputes as a subcategory to this one. We are currently, as far as general commercial disputes are concerned, we're currently representing a client in an ICC arbitration concerning the termination of an exclusive television marketing rights agreement against the African Football Confederation, the CAF, and likewise involved in many port concession disputes in Africa. Intellectual property, this one I like. We recently represented a global fashion brand against an Asian company for the abuse of trademark registrations of a world-famous logo. Now, I won't tell you what fashion label we represented, but I'll give you a hint. The fashion label sponsors a very famous tennis player who may or may not come from this country, and who may or may not have won the Dubai tennis championship a few days ago. So, going to the last category of disputes that I wanted to discuss with you, those are investor-state disputes. Now, a little bit about state disputes, because it is important, as we will see later. These are growing in the region very much. Foreign investment, as we know, this is high capital, long-term, significant political risk type of an investment. It is something that states want to attract for development. We heard many speakers at this forum on the issue. And when we think of FDI, we think factories, we think power plants, we think concessions, we think roads. Historically, these disputes have been imbued with an important political dimension. Why? Because of the foreign element, because of the political risk. When you invest abroad, you take the risk of an expropriation, you take the risk of regulatory change, you take the risk of cultural incompatibility. Recently, we saw in the Oscars the best documentary film that beat my country's nominee, Honeyland, was called American Factory. Now, American Factory is a documentary about a Chinese company investing in Ohio in the U.S. And whereas that part of the U.S. is currently struggling, and they were very happy to receive millions of euros in investment, very soon there was an important cultural conflict between the American company and the Chinese company and the American workers, given the Chinese 7-day-a-week work productivity demands. All of these frictions can result in Chavez saying, I want that, that, and that. being expropriated and so on. All of that can lead to investment disputes, and they are very, very prevalent. Historically, investment disputes were resolved in a sense via political means. Investors were reluctant to go to the domestic courts of the home state for reasons of fear of partiality and bias. At that time, investors had to call up on their home state, and then if the home state was more powerful than the state in which the investment was made, then you would have pressure being exerted, and in some cases back in, let's say, in the 19th century, even gunboats being sent to protect the foreign investment. In the second half of the 20th century, we have a change from politics-based resolution to a rules-based resolution of disputes. This is largely based on a very significant network of international investment agreements, most of them bilateral, some multilateral, which we can call BITs. The idea of the foreign investment treaties, foreign investment protection treaties, was that the legal protection of investments may lead to a stimulation of foreign investment by eliminating the sense of political risk. That was what the state was hoping to gain, whereas investors were no longer could obtain protection in a legal way. So this is a domain that has led to a proliferation of arbitration in the world. There are now over 1,000 arbitrations in the investor-state domain, and as we will see later, there are nearly 100 investor-state disputes in the region. Now, so what does investor-state arbitration look like? Well, first of all, who is protected, and what are the standards of protection, and what is the type of dispute resolution that we see? First, these are international law-based disputes, meaning that an investor can sue on the basis of a treaty concluded between two states insofar as the investor meets the criteria of investor in the treaty. The other thing is that these standards of protection, these treaties provide standards of protection such as non-discrimination, fairness, fair treatment, compensation upon expropriation. This is what an investor gets. And the other thing that these treaties afford is direct access to a neutral forum via arbitration. If we compare that to commercial arbitration, the differences are clear. One is that national law applies generally in commercial cases. International law generally applies in investment disputes. One is confidential, the other one is transparent as a result of the public interest issues that arise. And usually one involves an international responsibility of the state in the investment arena and the contractual responsibility of the party in the commercial arbitration world. Two more points that I would add to this is that first, as Jenny mentioned, commercial arbitration is slightly quicker than investment arbitrations. Investment arbitrations can be very complex. And secondly, enforcement against companies is easier than against states for reasons of sovereign immunity. We are one of the world's leading practices in investment arbitration. We represent states and investors alike, and we act as arbitrators in investor-state disputes. Maybe two milestones that I will mention are the fact that we have secured the largest award in history of $50 billion for the UCOS majority shareholders. And we currently represent China in its first investment treaty arbitration. Jenny, I don't know if you wanted to mention something on Ukraine? No. So just because we're running out of time, I'll quickly lead you to my last topic of today, which is international arbitration in the region. International arbitration is truly booming in at least information about arbitration is booming in the region. All parties in the SCE region are members of the New York Convention except Kosovo. All countries are members of the main international investment, multilateral investment protection agreements. All of the countries have domestic arbitration courts, which are seeing a very important rise in domestic arbitration cases. And importantly, all of these states are significantly involved in investor-state disputes. And that number is currently 86. You can see on the map the number of investment disputes against the individual states in the region. The leader is Romania, followed by Croatia. Most of the investor-state disputes in the region arise in the area of energy, finance, and construction, and the biggest investors who have sued these states are coming from Austria, Netherlands, Cyprus, Greece, and Italy. There will be more disputes in this field, so stay tuned. I'm going to pass on to my colleague on state contracts.
So basically you can use arbitration with everything. So I'll quickly cover the topic of smart contracts. And when we're here to discuss Industry 4.0, we inevitably discuss blockchain technology. And the term smart contract generally refers to a piece of a computer code that is basically defined to execute certain tasks if certain preconditions are met. So not all smart contracts are actually contracts in a legal sense, as we lawyers would define them. So we need to be careful whether a certain smart contract actually is valid under the governing law. So let me, for example, show you the first slide with main characteristics of a smart contract. So it's a digitalized transaction, meaning that it's completely reliant on coding, so no paper involved. It's immutable, which means that the coding is not meant to be changed, and basically that means that no one can tamper with the contract or breach the contract. Automatic means that it's performed by computer, so we're here trying to reduce any human involvement. And self-enforcing actually means nothing more than if something happens, then something else will happen. That's this ability of a contract to perform on its own that makes a contract smart, basically. So no intermediaries here, also it's relevant, and that's something basically that's the main characteristic of a blockchain technology. There it's a peer-to-peer basis, so if anyone has issues to trust in banks or with any intermediary here, there is no issue with that. So if all this sounds a little bit abstract, I can give you an example of a drinks vending machine. So imagine, for example, you would like to get a drink, you put money, you put a coin, and then when the money is paid, an irrevocable set of actions is just put in motion. The drink is supplied, money is put there. So if you want to change your drink, you can't. If you want to get the money back, you can't. And that's basically a smart contract. But, I mean, also they're used in many different industries. So for example, they're very attracted to insurance industry. So, and it's something that is, well, normal, because these kind of companies actually deal with so many different claims and claims payments requests at the same time. So if you can imagine here having a company giving a flood insurance to a large number of people. So it's just insurance against flood. And we dealt with flood in Serbia a few times. We can kind of relate. So what would happen here is that a smart contract would basically say, if rainfall reaches a certain level, a certain threshold, immediately the payment gets to the insured people. So there is no need to make a request to go to the insurance company. So basically in that situation, everything is written on the blockchain. Once the rainfall reaches such a threshold, information is put on the code, and just attributes the payment to the insured. So there are other examples which I won't have time to go through. One of the examples that I really like is this tracker thing, basically, which is a software-based platform that is used by diamond industry. So they're basically using smart contracts to check every diamond where it's the provenance, the provenance, the quality, the clarity, and then it goes like from provenance to the final owner, and they basically track everything only with smart contracts. So I mean, all of this is to say that smart contracts are not necessarily impenetrable. Okay, we don't have any more time. Just I want to tell you, there are disputes even arising out of smart contracts, and as you can imagine, they can be solved by arbitration. So with this, I thank you. I can actually ask if anyone has questions from the audience, but I think we kind of ran out of the time. No questions? Thank you very much for your attention.